Hello, everyone, and welcome to Designing Justice. I am Priyambada Shivaji, and I'm joined by my colleague Shreya Tripathi. We are part of the Justice, Access and Lowering Delays in India initiative at the Vidhi Center for Legal Policy. Through this series, we will be speaking to various stakeholders in the justice system to identify areas ripe for intervention and potential solutions for building universally accessible, future ready, and better courts for all users. Today, we're speaking with Anchal Bhateja, a research fellow with Vidhi. Anchal is one of the few visually impaired women advocates to argue a case before the Supreme Court of India. Her work as a lawyer and researcher continues to create new milestones for disability representation in India's legal profession.
Thank you so much for joining us, Anchal. This, as we mentioned, this will be a free-flowing conversation. We'll start off with a few questions to highlight your experiences with the system, and then move on to the efficacy of potential solutions that have been provided by the court and that could be implemented to ensure greater accessibility for all. Uh, Moving on to the first question, we would like to start by asking you, what motivated you to enter the profession, and how has your experience evolved over time? That is, in your experience, how has this changed from being in law school to being the first, to be one of the few female lawyers with visual impairment to appear before the Supreme Court? How has it evolved over the years?
Uh, I am a late blind person. I lost my eyesight only in 2016 when I was 16 years old. Uh, Before that, and just a year before that, I'd lost my mother, so I wanted to become a doctor. But as soon as I lost my sight, that option was completely foreclosed because even today, as we see, a lot of disabled candidates would try to get into a medical school, but then they are denied admission that they have a disability. And me, with my 100% blindness, there was no way that infrastructurally I could be accommodated in a medical school or to enable me to become a doctor. So after that, I felt very devastated because I really wanted to become a doctor. And my father said that let's look at other specialized courses that can provide you some kind of employment opportunity. While we were thinking about it, I also spoke to a few village panchayats in around my city, and all of them told me that the blind people residing in those villages didn't have any job or education, and they said that, and it was a very presumptive answer as well, that they are blind. What would they even do for themselves? They can't even eat food on their own, and they can't even take a bath on their own. So that was a very hard hitting conversation that I had. And after that, I wanted to do something for the community. It started with me going to the district administration and asking them to set up a vocational rehabilitation center in our city so that these blind people could be trained in computers. This was my first encounter, and it really fascinated me that uh, a conversation with the state can come up with a tangible solution to a problem on ground. So my father said that if you're that interested in these kind of negotiations and conversation, then maybe law could be one potential area that you could pursue. And that was one of the reasons that I started preparing for CLAT. The other reason was simply that I was lost. And then I took CLAT, and I went to National Law School Bangalore after that. Uh, there also I was the first visually impaired student, 100% visually impaired student to go. Uh, Before me, there have been some partially visually impaired people, but they didn't have any difficulty with independent mobility. For me, it was an additional challenge because the campus was not very topsy-turvy and not very accessible, and audits, etc., had not been done infrastructurally as well as digitally. Resultantly, the physical infrastructure was also not very accessible. They didn't have any knowledge about OCR and reading materials accessibility, and how to make documents, for example, screen reader compatible. So all those conversations had to happen from the scratch. Even I didn't have a lot of knowledge because I didn't have anyone to look up to. So I found other, like, people from other colleges who had graduated way before me, but not particularly from NLS. But it was still a unique experience navigating with the administration because no one had done that before. Uh, but with time, it was a constant conversation. I often say that they got used to my accommodation requests, and I got used to their inaccessibility. It was a constant exchange between us. But eventually, like 5 years went off, and I graduated. And after I first started off in a corporate firm, and after that, I switched to Vidhi, and alongside it, I also decided to start litigation because I realized that Vidhi was more of a ex ante intervention, that you like try to design laws uh, that ensure that there is less litigation, but on the other hand, there's only so much that can be done on an ex ante basis. There's only so much that you can anticipate while drafting a law, and a lot of questions, a lot of reliefs still fall through the gaps, and judiciary is the only answer, and like court litigation is the only answer to those gaps. And that is why I started thinking of litigation as an option. And then I thought of venturing into disability rights because that's my core area, lived experience, and also like an academic interest. So yeah, that were pretty much the motivations behind entering law and specifically venturing into litigation.
That was very interesting. Just a sort of follow-up question to that. You said it was an ongoing negotiation and conversation with the administration at NLS and with people at courts to have these accessibility tools, to even bring that to their attention, right? Do you feel that this is something that is, how do we ensure that this particular hurdle can be crossed and ensure that there is greater sensitization and awareness on the part of the registry in the courts and lawyers, advocates associations, and other people in this position of power to ensure that they also take on board this need for improving accessibility?
So it starts with the foundations. First is to have conversations about disability in law school and in judicial academies. Because I had myself done a survey of curriculums across national universities, particularly. There wasn't any conversation on disability except for a few electives on disability here and there, but they were purely like they were choice based, and they were very like ad hoc and sporadic, nothing structured as such on RPWD Act. Similarly, judicial training also doesn't have segments on RPWD. Judges don't really know about it. That again trickles down to all stakeholders in courts, be it the registry, be it lawyers, be it judges, be it the staff. So this sensitization cannot happen when the person has started working as a judge or as a as a staff in the court or as a lawyer. It has to happen at a foundational stage. That is the first intervention. Second intervention is to have targeted training and sensitization programs on a continued basis once the person has started working. They will be more effective if the foundations for inclusion and disability rights have already been laid in the mind of the judge or the registry or the staff. Training and sensitization programs need to be done on a continuous basis. Conversations should not just be about what all can be done. It is also about explaining to courts and explaining to other stakeholders that what are the consequences of missing out on these details, what are the consequences of not having filings that are not accessible, for example. Then of course, one natural corollary to that is to provide them the resources to ensure that this happens, like OCRing softwares might be expensive, and if they are not provided to registries, then the question of making files accessible goes out of the picture. So it is also to ensure like resources, that the resources are provided. The training is also provided to the registry as to how to create OCR files, for example, or the people maintaining the court's website. What are the accessibility standards under the RPWD Act? They are the BIS 18702, which is identified under Section 40. They should know what digital accessibility really means and how it can be ensured. So it is a combination of foundational as well as practical continuous interventions that need to be taken, and it is more about intentionality, because eventually everything boils down to that. Who um, who even provides the questions around what kind of budget would be provided to judiciary in general. What kind of budget would judiciary allocate to disability issues? How will the people on ground utilize that budget? How will the people on ground will they see disability accommodation as a necessity, as a mandate, or they will see it as an additional burden? So it's eventually about changing the intentionality, which will happen in found small foundational steps, and on a continuous, it needs to happen on a continuous basis.
So, I mean, this is a great segue to one of the questions we had. Essentially, you spoke about how continuous education is necessary.
Hmm.
Currently, in your experience, what has the reaction of the different stakeholders in the justice system been when some sort of accessibility tool, or even, I guess, like you said, OCR is has multiple purposes, right? It's technologically also it's a helpful tool. So when
Mhm.
some of these tools are introduced, what has been the reaction of various stakeholders? And here I mean, like, not only the judges or the bar, even the registry. Like how has, in your experience, how have they reacted to introduction of any such new technology which improves accessibility for different users?
So it is a varied response, right? Like someone like Justice Chandrachud would say that, okay, you digitize courts. So maybe he will be more comfortable with a complete soft copy of the case. Or someone working in an older judge who is working in at the district court level, who's been working in that setting for maybe 20-25 years. They may not be that open to that idea. So it's a varied response. Judges may see it as a good thing or a bad thing depending on how they perceive technology itself. Uh, Lawyers may sometimes feel it as an additional burden because there are set practices of how you file. You type the file out, then you get it printed, then you get it signed by the client or stamped, and then notarized, then you upload, like you scan it and upload it back. So this requires an additional step, like of ensuring that the final filing that is happening is accessible. So this is the experience of one of my colleagues. They were in a cat, like he was in a cat hearing, and the opposing counsel said that it is not my responsibility to provide you an accessible format, document in an accessible format, and the opposing counsel had filed the response about 10 minutes before the hearing. And my colleague said that I cannot access it. How do I even argue in the court on the basis of this document? And he said, I'm not obligated. And after that, the conversation went before the court, and then the court asked the opposing counsel to take the necessary steps to provide copies in an accessible format. So again, lawyers also vary. Some may see technology as a good thing, some may see it as a win, and then depending on that, they may have different reactions to it. Because disability conversations that don't happen on a regular basis, it's not even considered that big of a deal. All that it becomes is a one single logistic step. Some may just see it as an additional burden, alongside 100 other things that they're doing. So that may change how someone looks at disability accommodation. Likewise for registry and others, like they have some steps have been taken. The Delhi High Court, for example, they say that if you are a disabled litigant or a disabled litigator, you can indicate to us, and then we will ensure that your case is listed on the top of the board. So those kind of additional steps they are taking. But then which registries are we even talking about? Like one Delhi High Court registry has become more responsive because there are continuous efforts from the bar. There are a bunch of disabled lawyers working in Delhi, which is why there's continuous conversation. There's a Delhi High Court accessibility committee where conversations keep on happening. But are the registries of other high courts even responding to it? Do they even know about disability accommodation? Have they even seen a disabled lawyer to start with? Can we provide accommodations only in the courts where there are disabled lawyers, or it should be a matter of universal access, that even if there's not even a single disabled lawyer in Mizoram High Court, we still need to have accessible courts? And then again, it's a question of the question of chicken and the egg, right? Is there no lawyer before the Mizoram High Court because Mizoram High Court is not accessible, or because the High Court is not accessible because there's no lawyer? So somewhere we'll have to start, and it'll have to start with integrating universal design in all walks of life, in all courts, right from the top to the bottom, so that lawyers also feel more comfortable. There's so many people who come to me and say that I am blind, I want to litigate. How do I litigate? I want to go to the trial court and litigate. Trial courts are not just inaccessible, they're unsafe. There'll be wires dangling here and there. So the conversation has to start somewhere. Um, Yeah, sorry. Yes.
That's been very helpful. Just wondering, perhaps, so as you said, some courts, like the Delhi High Court, have taken some steps for ensuring accessibility. But
Mm-hmm.
are there any additional assistive tools or technologies that you could suggest that you would say would need to be taken up further to push the envelope a little bit further for ensuring that more people can use the system?
Right. So one is the OCRing itself, and the court alone can't do anything. For that, litigators also have to comply and cooperate that they do their filings in an accessible format. After that, it's on courts to ensure that their websites are accessible, they're compliant with the notified accessibility standards, and the orders, etc., that are uploaded are in a screen compatible format. Then it is to ensure that there are some kind of support systems available to lawyers with disabilities, right? So for example, the job access with speech software that I use for my computer, its corporate price is around 80,000, 90,000, and it is a very like huge cost for a person who's setting out this foot in litigation, and litigation, we all know how much it pays. So other kinds of supports could also mean providing some support by the court for courts and like judiciary in general, to help out lawyers to procure softwares, etc., through which they can participate in the judicial system equally as lawyers. There are again optical character recognition softwares like AB Fine Reader and a bunch of others that can be provided by the courts or through other funding mechanisms. It can take the form of CSR, it can take the form of other kinds of fundings. Uh, that is one another step that could be taken to enhance access to aids and assistive devices for disabled lawyers, so that they're able to function at par with their able-bodied counterparts.
So just to follow up on this in terms of like technology or tools that are being used, physically also many of the at least high courts and even the Supreme Court, they have a bunch of like accessibility tools. Like they have ramps, they have tactile pavers. In some places there are tactile maps, etc. As the user or as the litigator of these courts, do you find like these are properly usable for you? How useful do you find them
Yeah,
essentially?
so see, I would say, and I speak from the perspective of a person who's turned blind about 10 years back, and I'm not blind since birth, so I'm not very good at mobility myself. But I often wonder also that the court is a huge complex. And if I have to run and reach court in time, there is no way I can follow that tactile path. Because the A, I don't know the orientation of the court, and B, it is so crowded that if I use it, there is a very high chance that I might just fall. Like uh, I might like stumble into something, or I might bump into someone and fall down. So in those cases, given the overall infrastructure of our courts and the way the judicial system is designed, it is very, very, very visually oriented. Like even to check which matter is going on, it requires sight. Has the judge risen? Uh, are the mentionings happening? Is the mentioning over? You know, is the judge coming? uh, which side to stand, whether to stand at the petitioner's side or the respondent's side, which side is which. All of these questions are so visually oriented that it's impossible for infrastructure alone to uh, reach that stage that a blind person just able to navigate, because that's the inherent design of our judicial system. We have easy, like in every court we have hundreds of matters listed every day, and we would see 300 400 people coming to one single courtroom every day, and the crowd makes it very difficult for a person with disability to navigate on their own, not just like persons with blindness, but also persons with mobility issues, persons with neurodivergence, because they might also face sensory difficulties in such a crowded atmosphere. So in those cases, one solution is like human support. Delhi High Court and Supreme Court have an accessibility committee, which the process is simple. You reach the court, and you call them up. They come at the gate. They take you to the court that you have to go. But there are resource constraints even in the functioning of these committees, because they have limited capacity. Imagine a day that uh, like 30, 40 like old people and persons with disabilities were to come to the court. They won't have the machinery to assist those many people. And secondly, this is just concentrated in Delhi High Court and Supreme Court. I am personally not aware of accessibility committees in other courts, other tribunals, lower courts, and high courts of other states. So that is a gap. When eventually, till the time we become a fully digitized judicial system where all conversations are happening online, or maybe we develop some kind of augmented reality where people can appear virtually in person, I think human assistance is the answer in the meanwhile, because it's very hard for a person with disability to navigate in a room full of some 200, 300 people. So yeah, that's how those tools can be like that. That's how like support can be infrastructure support can be extended to persons with disabilities. And again, this is not at all to say that universal design should not be aimed for, should not be achieved. It is a must, because it eases life for everybody, including able-bodied litigators, litigants as well. So, in the meanwhile, while that conversation is happening, how do we make our courts infrastructurally fully accessible and we achieve universal design? It's very important to have that in the intermediate, have that human support to help disabled litigants and litigators navigate courts. And again, I would say that universal design is a very, very far off dream. It will maybe take a century to reach there.
I mean, we agree. But the design handbook that we have also, proposed, that also aims for universal design. I mean, there's a long way to go, but we have definitely aimed for it. And also, just to clarify, I mean, all high courts do have accessibility committees, and like we have seen quite a few of them being quite active. But yeah. From that, Priyanka, you want to move on to the next question?
I just, the point that you made about how human assistance in the short term is so crucial. Some of the other, experiences that we've heard from other advocates with disabilities navigating the system has also been that in the absence of adequate resources, adequate training, it sort of, compromises on human dignity when the persons who are assisting you aren't also trained to be sensitive and aren't, inculcated with that same mindset of why this is important. So I think this, would you also say there's, a fine line to be drawn there between how do we ensure that dignity is preserved while assisting persons with disabilities, while also, not taking that as an excuse to sit back and say we won't try to be better.
Yeah, so I would go back to my again like very basic point on how disability conversations need to happen at a very young age, right from schooling, right in college, so that people who eventually get recruited in these accessibility committees, people who are litigating in these courts, people who are just the general staff, security guards, everyone, they treat persons with disabilities with dignity. See, it's also about resource constraints, time constraints. There have been a lot of times that accessibility persons have taken me to court and then they said that, madam, we have to go somewhere else. So you figure it out, things from here. And I said that I am at the last bench in the court, and when my item is called out, how will I go there? Because there's so many people in front. But they usually said that, okay, we don't have any other person. I'm looking after everyone who needs assistance today. So I don't know how to help you beyond this. So there are resource constraints, capacity constraints, time constraints, that despite all good intentions, despite training and sensitization, make it very hard. So one is definitely to have more conversations, continued training and sensitization, how to uh, be courteous with persons with disabilities. But it's also important to ensure that there is better capacity and like better resources also, so that one person is not overburdened with like so many like assisting so many people on one particular day. So that also has to be ensured at the same time.
Okay. Thank you so much, Anchal, for taking out the time and speaking to us. Thank you for sharing your experience with such depth and honesty. Like you said, it's very important to have these conversations and continue to have these conversations. And that is the complete intention of this video series, where we want to speak to, stakeholders, many stakeholders that um, interact with the justice system and how their experience has been as they interact with it. With that, we can, I think, wrap up this episode. And yeah, hope to see you with more.
Thank you very much.
Thank you so much.